This is Attorney Joseph Ott. I'm here to discuss with you today a topic of great importance to understanding the claims process for your workers' compensation case. That topic is the history of the workers' compensation system in general. This topic is of more than just academic importance because it informs the way that the employer's lawyer and the judge will look at your case. And it also informs how you, in order to best serve your case, should receive medical treatment and communicate with the other side. The workers' compensation system was originally devised towards the end of the 19th century. From its inception, it has been intended to serve as a compromise between the interests of employers and their workers. Prior to the implementation of the workers' compensation system, an injured worker was allowed to sue their employer, but only if the employer was negligent in performing some job site duty. For instance, in setting up a machine in a proper way, providing adequate security, etc. This system, combined with the development of large-scale industrial manufacturing, prompted workers who were injured on the job to file lawsuits, as was their right. However, because in the civil justice system, the workers were allowed to recover for pain and suffering damages, and because there were so many injuries, these lawsuits often caused employers to go bankrupt or to largely reduce their workforce. In fact, employers began to use aggressive defensive litigation tactics in defending the claims, causing workers to be unable to recover for years after their on-the-job injury, even if it was only minor. So under the old system, both workers and the employer were suffering and were not getting justice. The workers' compensation system addressed this problem by allowing workers to recover without having to show any fault on behalf of the employer. This means that any job injury that has occurred while working is recoverable under the workers' compensation system. However, in return, the employers were granted the ability to settle the claims without recourse to a jury and without the ability for the worker to recover for pain and suffering damages. As a result, the only amount that a worker is entitled to recover for an on-the-job injury is precisely defined by the statute. I'll discuss the statute and the value of your claim in a different video. The important thing for now is just to recognize that the historical legacy of the workers' compensation system allows you to recover for any on-the-job injury, and that system will not allow you to recover for pain and suffering damages. I think it's important to recognize this history because many employers nowadays forget about it. Employers contend that the workers' compensation system benefits the worker because it's so easy to file a claim and get a recovery. That just isn't true. The workers' compensation system has always served for over 100 years to protect the interests of both the employer and the employee. Nowadays, though, employees are often taken advantage of by employers who misunderstand the historical situation that produced the system we have today. For this reason, it's very important that you consult an attorney about your case.